on site, look at invoices. I mean, again, like I said, we had to talk about internally, and like I said, audit would definitely be something that I would recommend to go outside. So.
True. So again, this poses the issue that we have a contract and we can't, the vendor is unwilling to provide us information. It seems like whether that be a report, it should be, I would assume, easy to run a report out of a system to show charges. Most systems, I would say, most modern systems allow you to run reports in Excel and be able to populate that data or send us copies of the invoices. So I know as a towing committee, we recently got copies of other vendors' towing bills, so those were provided, but yet we don't have any, except for ones that people have sent to us, we don't have anything from the vendor to substantiate this. We hired them to do this, and they don't want to give us information to show that they're adhering to their contract. That's a problem to me.
Chairman.
Councilwoman.
So, I don't recall, did we ask for all the invoices for like the 1,500 tows for the year?
In the letter, that was what was asked for. Obviously, certainly open to a lesser amount if that's what we have to take to get to ensure. And again, I can only base what I'm saying based on the invoices that have been sent to me. That's all I can do is just factually looking at invoices that have been sent to me. I took those, looked at the contract. I'm not in the towing industry. I'm not a towing expert. But I can match up line items. You know, I can say basic tow rate, 150. It doesn't say per hour. It says 150. And again, other line items say per hour. So one would assume that if it just says 150, that's a flat rate. Multiple invoices that I have say 150 times 1.5 hours. I know I asked that question. I got a response that says, well, it's more than a basic tow because it's an accident. Well, isn't that what we essentially mostly hire them for? I mean, I know that there's broken down vehicles, but I would say in general, if we're calling for a tow, it's normally because of an accident. But again, that's my assumption. So I'm asking Corporation Counsel, I'm asking, you know, what can we do to get the information we need to ensure that our vendor is in compliance?
Councilwoman, from what I hear you saying, is there needs to be a third party, and we look to Jason and Corporation Counsel and the administration to come up with the appropriate level of you know, who that third party would be, and then bring that back before the council, and then we can approve that expenditure. And I, like you said, there's different levels. Are we going to spend $500,000 in doing an audit, or I have no idea what that charge would be, but I think people have been consistent with that, or the council's will is to dig into the data, right? There's been a lot of email correspondence, lawyers and everything else, but if you haven't been afforded, you know, the access to the data, then it's kind of hard to do a proper analysis. To be able to say, is there an issue or isn't there an issue?
Correct. Yeah.
People being charged fairly or not?
Chairman.
Yes.
Maybe a suggestion would be for the towing committee to pick a time, like a period of time that's been the same for a whole year. You know, I ask somebody to give their documents for a whole year. Maybe choose a random, you know, from the committee or just from, you know, from you. You know, just pick a random time, like 3 months or 2 months or whatever, a smaller sampling. They won't know which time that is, so it probably would be representative of, you know, would be able to be used for an audit, and maybe it wouldn't cost as much as a whole year's worth of audit.
So, Chairman, I would agree. And again, I'm open to different, just for asking for the data. Again, we signed a contract. I know that if you read the contract, plain language, right, it says that the director of finance can go on. I would hope that as a vendor, if they're adhering to the contract, they'd send us invoices. I find it frustrating that we have to spend money to get something that I think should be sent to us. But I'll move on to my other items. So speaking of the towing rates, and I've talked about this before, learned way more about this than I ever cared to, but if you go to get your vehicle, it's towed, you have to either pay the full charges that they say you owe at the towing vendor, or you can go file in court and file a bond in that same amount. So no matter which way you do it, to get your car out, you have to pay the full amount that they say you owe, if you're disputing the reasonableness of the tow rates. The document that our vendor requires people to sign, well, I've been told it's voluntary. I've heard otherwise. Again, I don't have personal experience, but people who have been there. Their item 5 that individuals sign to get their car says, agrees that the towing and storage fees are reasonable and that the police complied with the procedures established. So you've now taken away the one remedy that people have in court to challenge the reasonableness of towing. I watched the recent case, an individual who had been here, and this document was produced in the case, in the trial, to say, well, you signed this paper. How is that right? Why are we not mad as a city to tell the vendor, you cannot have this in there? Again, that's their only remedy. They're stuck. We entered into a contract, they want to get their car out, they have to pay the fee. I've been told, I've heard, I think someone mentioned, it's voluntary. Then we should tell them that you need to put voluntary very big at the top of the form for people that they know they don't have to sign it. So I have a problem with that, because again, they have one legal remedy, and the vendor's taken that away, because this is a very easy document to provide in court that says, well, Mr. Johnson, you agreed to this. Then what does he say? I signed it under duress? I mean, that would be his only legal argument, I would say.
Chairman, do you know in your research, did you learn whether or not they can get their car if they don't sign, if they opt out of that? Do you know that?
I do not know that. I only know, again, this is just based on individual experiences that went in that said that they were made to sign it. Again, it's individuals. I didn't experience it myself, so I'm only speaking about individuals' experience, but again, it shouldn't be in there. That line item should not be in there. We as a city should tell our vendor, you cannot make people, that shouldn't even be in the document. Because again, that's their only legal remedy. So you're taking it away. It's like signing, I'm working HR, it's like making someone, no federal laws or state laws apply to you. You can't sue us. Like, that's not right. You can't strip people of their legal remedies. So my last item is talking about the restoration. And so we did, that was the third motion was directing Corporation Counsel to investigate the road cleaning and remediation. I think there's been some progress on that a letter was sent saying that the fire department, would be the determining factor whether remediation was done. I'm doing my own checking too. I have some feelers out there for information, but one question, in the last council meeting, I brought up the case of the individual who received a letter that's addressed to their insurance company, copied to them, and it says, your insured is responsible for this cleanup work. If you don't settle a claim with us, we're going to go after your insured. We're going to sue your insured because we as the vendor do not have the legal ability to go after the insurance company. It says it in their letter. They don't have the ability to sue the insurance company. They only, according to their letter, only have the ability to sue an individual. So the two Taylor residents that were here at the last meeting, they got that letter, and then they recently got a debt collection notice that changed their alleged debt owed from $18,000 to $26,000, brought it up in the last council meeting, and as I predicted, it was a mistake. It was a mistake. They don't go after individuals, they only go after insurance companies. The debt collector is only supposed to go after insurance companies. My question that I asked two in my emails. One, if you can't pursue a claim against an insurance company, how is the vendor having a debt collection company pursue insurance companies? It doesn't make sense to me. If they don't have a legal claim against the insurance, how are they even sending that to the debt collector allegedly to pursue it? So that's one question. The second question that I'm going to send a follow-up email, I asked, are they pursuing any individuals for this remediation work, or have they? And I didn't get an answer on it. So I'd like an answer on that. I want the company to say they're not seeking any of this work that they allegedly say they have to do from individuals. And I think that needs to be answered because, again, somebody getting a letter at home that says that they may owe $8,000 or $16,000 or $26,000. I spoke with Michelle on the phone on a Saturday. She's like, do I need to retain an attorney? And I'm like, I can't tell you that. I can't. I don't have the legal expertise to say whether you do or don't, but a person shouldn't have to experience that. They shouldn't have to worry about spending thousands of dollars on an attorney to pay a charge of cleaning up some coolant from the roadway that I don't think is necessary. So, sorry I was long-winded, I just wanted to cover all those items.